Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello, and welcome to Hull on Estates. You are listening to episode number 683. I'm Stuart Clark.
And I'm Aaron Chin.
And hello, Happy New Year's there. This is at least my first podcast of the new year. We're recording this the first week of January. So, welcome 2024.
Same with me. Happy New Year's to you too, Stuart.
I think we have an interesting kind of topic, I'll call it, to discuss today on our podcast. And this is an idea I have scared more of my, adult friends with this fact than I think any other kind of, legal, interesting, factoid to point out there. And that is basically Section 32 of the Family Law Act, which imposes an obligation, potentially, on adult children to support their parents. And yes, you heard that correctly. I did not say the obligation of a parent to support a child. I said the obligation of a child to support their parents. And this kind of course, flips the dynamic you normally think of when you think of, child support, quote unquote. This is, I suppose you could call it parental support. And I wrote a blog about this a few weeks ago, and I got some heated reactions from people who just went, wait, did I hear that right? Is that actually a thing? And it is. It's a law in the books, and it's something that I thought we could talk about today just because it's an interesting area of the law that is rarely spoken about and explored. Obviously, this from the reactions people didn't know it existed, and when they find out it existed, kind of went, uh-oh, what does that mean if I don't like my parents? So I thought we could talk about that today. And maybe a great kind of jumping off point is just to read the actual phrasing of the statute itself, just so you can understand in clear, no uncertain terms what the statute says. So as I said, it's Section 32 of the Family Law Act, and it says, verbatim here, every child who is not a minor has an obligation to provide support in accordance with need for his or her parent who has cared for or provided support for the child to the extent the child is capable of doing so. And that's it. That's the whole section. It seems pretty basic there. You child have an obligation to support your parent so long as that parent cared or provided for you and you, the child, are capable of providing support. Seems pretty basic, but then we have a few cases we want to kind of talk about of where it's been applied. Because truth be told, it hasn't been used that frequently. It's kind of a rarely used section. And as I said, the phrasing itself is fairly broad. So maybe, Aaron, we can jump into the Dragulin case. This is a case from 1998, so we are going a few years back. But Dragulin versus Dragulin, 1998, Canley, 19365. So Aaron, can you maybe give us a very basic kind of summary of what happened there?
Sure. So in the Dragulin case, we had an unemployed 73-year-old plaintiff father who was receiving income in the amount of about $12,000 annually from government pensions. He became estranged from his defendant daughter. His daughter was employed as a clerk with Canada Post, and she was earning about $35,000 annually. The court noted that she lived a modest lifestyle. She lived in a home that she shared with her mom and younger sister. The daughter paid a disproportionate share of the taxes, and her younger paid rent. Now, the extra element to all of this is that the daughter had previously won the lottery a couple of months back in the amount of $1,030,473.90. And so the court, I think, took a pretty cut and dried approach here. It applied the Section 32 test, as you already went over, Stuart, and pretty quickly found that the daughter had the capacity to provide support based on her annual salary and lottery winnings. And while the court also acknowledged that the daughter and the younger sister's evidence was that the father had been emotionally abusive to her and that the daughter had supported the family when she was 10 years old, it still found that the father had provided primary financial support for the daughter when she was growing up until she was about 10 years old. And finally, the court also found that the father had demonstrated financial need. He wasn't working anymore because of his age and he had vision problems, and he had reasonable personal expenses that far exceeded his government pensions.
Yeah, no, thank you. And this is the case, I think, which better than maybe any other, kind of underscores just the potential, perceived don't know if unfairness is the right word, but the fear if you are a child who has a bad relationship with the parent. And that is, as you said here, I mean, so the daughter in this instance, relatively speaking, had a job, a nice job, but was not making crazy money. And then, luck of all lucks, wins the lottery, right? You get this windfall of lottery winning. You've been estranged from your father. Her own evidence is, as you said, that her father was emotionally abusive towards her and her siblings when she was a child. Her evidence was that she had had minimal contact with him since 1984 when he left the family and there was a divorce. And then suddenly you win the lottery and knock, knock, knock on the door comes, a strange dad saying, hey, I lost my job. I, don't have any money. I heard you won the lottery. Can I have some of that? And the court goes, yeah, you can. And applies, very cold reading of the statute, which was just, look, did your father ever provide you support as a child? I mean, here, yes, until you were about 10 years old and he left the family. And do you now have capacity to support him? Again, yes, because you just won the lottery. So we're going to make an order. It was about $400 a month is what they said she had to pay him. So it's not, extravagant sum, but you're paying $400 a month potentially in perpetuity to your estranged father who left you and your family, decades ago. And you win the lottery and he comes out of the woodwork asking for money. The court says, yeah. And it's potentially a draconian kind of application of the statute. But it shows this, that this statute, at least, is still on the books. It can still be used to force support, even in circumstances where you are estranged from your parent. Dragulin, although maybe the most extreme example, is not our only example. There are other cases that I've talked about in my blog. I'll make sure to post on the blog on the thing. There's the Stavino and Buttonelli case, which was a 2018 case, 2018 ONSC 1041. Similar circumstances, well, not the lottery winnings, but 2 adult children were required to pay $350 a month in support to their parent. There's Godwin and Balsco, 1998, Henley 9312, where 4 adult children were collectively required to pay $1,000 a month to their parent in support. So there are cases that come along. And I know, Aaron, we were chatting before we jumped on the podcast today about maybe some trend lines that we're seeing in these cases. And I know you had some thoughts on that. You want to maybe jump in a little bit on maybe some trends that we might be seeing in these cases.
Sure. So when you had sent me a bunch of those cases to review just before the recording, I guess I had a feeling of dread when I had read Dragulin. And then you had also included a case called LFDVX. Now, this is a pretty interesting case because it seems to sort of move away from, I guess, that literalist draconian approach that Dragulin was taking. So just the facts briefly. So in LFD, what happened was that the applicant mother here, again, she was seeking parental support under Section 32. And the mother here, according to her, she had raised the daughter from the time of her birth. She was raised in a very affluent lifestyle. She provided her with all her basic needs. But at trial, the daughter testified that she had an emotionally and psychologically abusive childhood while she was growing up under the care of her mom. And the court accepted this evidence. Now, notably, like in Dragulin, there wasn't any dispute that the daughter had the ability to pay parental support. But the court also found fault with the applicant mother. The court found that the applicant mother had every opportunity to achieve economic self-sufficiency. She enjoyed the benefit of her second husband's estate. And she also enjoyed the proceeds of a divorce settlement from her third husband. And she was receiving income as a lawyer. At the same time, the mother also spent recklessly. She failed to budget accordingly, and she failed to save for her retirement. In all of those circumstances, the court found that no parental support was justified in the case.
Yeah, no, interesting, right? And obviously, I mean, there are so few of these cases that kind of get reported and come out that it's tough to peg a trend line if there is one. But, Dragulin 98, I think that was a few years ago, I believe, so a more recent case. So
2016.
2016, yeah. So we're talking about, just under or just over, approaching 2 decades almost, I suppose, between those two decisions. And the one, estranged father, lottery winnings, yes, you can get support. And the other, potentially allegedly abusive mother, you can provide support. There's enough money there, but no, I'm not going to order it. And, the statute itself hasn't changed between those 2 times, but maybe you're seeing a court being a bit more critical and restrictive in its application. And that could be potentially a trend line. I mean, I agree. Maybe we are seeing it more restrictive, or at least the court's more willing to interpret bad behavior or alleged bad behavior on the part of the parent. So it could be interesting to see where these go, if at all, right? We're getting an aging population. Who knows how many, of your elderly parents may not have saved enough money for their retirement. And as written, Section 32 of the Family Law Act appears to give pretty broad discretion to the court to order support. But maybe we're seeing a more restrictive application in the more recent cases than we have in the historic ones.
Yeah, just to jump on that, Stuart. So, I'll contrast two different quotes that I pulled from the cases. So, in Dragulin, now one of the quotes that I have in court here was when they were ordering that parental support. The court stated here, quote, "The parent need not show both support and care. Moreover, the act includes no defense of fault or misconduct in the award of parental support, nor does it take into consideration the nature and quality of the current interaction between parent and child." And then we go to LFD. The court almost does a 180 here and says, quote, "A finding of entitlement to parental support from a child cannot be made in a vacuum without a fact-driven analysis of the history of the relationship between parent and child and the reasonableness of an applicant's purported need, specifically including why that person finds him or herself in a situation of need at all." So yeah, I think, to your point earlier, I think that while the relief it's definitely on the books, I think it's taken on a much more modern, maybe restrictive dimension than before.
No, yeah, you very well could be right. And and obviously in the latter one, in LFD, the court is, kind of, not just looking at these two people in a vacuum and saying, hey, you have money, hey, you don't, can you support them? It's actually looking at the nature of that relationship and, almost a moral, interpretation of, is it appropriate to award support to this parent in light of the surrounding circumstances? And at least for me, objectively from my own personal standpoint, I think it's probably a more fair application of the statute. It seems pretty unjust in Dragulin that this, person who's been estranged from their father and has alleged, verbal abuse as a child, hadn't spoken to them since she was a kid, wins the lottery and he comes out of nowhere and says, "Give me money," and the answer is yes, you have to. I think you'd tell most people that fact pattern, they say, wow, that doesn't seem pretty fair. But as the statute is written, was an outcome that could very well happen. But then you see in LFD that more fact-based analysis and interpretation of relationship, and the court said no. So it's interesting to see where these go, right? But it is still a law in the books. It's still there. These cases very rarely come before the courts, so there's not a ton of jurisprudence one way or the other. So you could pick and choose, I suppose, to a certain extent, how you want this to go. But I'll be curious to see where this goes in the future. And it's still there. If you have a fact pattern where you think you're on for an elderly parent who needs money for whatever reason, and there's a child there who has money, and as written, they may be required to pay support. So there's another statute to have in your back pocket as a lawyer, but also just to scare your friends at cocktail parties. If they have a bad relationship with their parents, say, hey, guess what? That parent of yours can come after you for support, so you better be, nicer to them or whatever it is. But no, it's an interesting area of law, and I personally find it interesting. I'm curious to see how and if it's used in the future and where this goes. But yeah, no, I think that's probably it for us for today. So yeah, Section 32 of the Family Law Act, still there. Children beware, you may have to support your elderly parents even if you don't like them. So, it's an interesting area to work through, and we'll make sure that those cases are posted up along with the excerpt or intro to this blog on our website. But otherwise, until next time, you've been listening to Hall in the States. I'm Stuart Clark.
And I'm Aaron Chen.
Thank you for listening.
Thank you.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.